Hello everyone, how are you all? I hope you have followed the other videos of a law where I have been discussing about various questions. Also, practice set papers have also been discussed. And do refer to the law contents that were made where there will be enough knowledge and insight so that you can answer all these practice set question papers, and definitely that will add value to your examination where you will be able to score well. So beginning with this set paper, see the first question that we have here is, at the end of tenancy, if the property, particularly a house, required some repairs, in legal terms, it is called lay repairs, derelict, dilapidations, or none of this, which will be the correct answer. And I think you all know this, that the correct answer is option number C, that is dilapidations. I'll mark this option C as the correct answer, dilapidations. It's not called the repairs or derelict or none of this. It's option number C. Moving to question number 2. Who is the first former Prime Minister to appear in a court as an accused? Option A, Indira Gandhi. Option B, Guljari Lal Nanda. Option C, P.V. Narasimha Rao. Or option D, Rajiv Gandhi. So we all know this. It was a very famous case, and the correct answer is Indira Gandhi. Indira Gandhi was accused and was taken to court, and she appeared in the court, who was the first former prime minister. Moving to question number 3. Question number 3 says, in case of a legal separation, husband is obliged to maintain his divorced wife for 20 years till the children become adult, till she gets remarried, till the marriage of the eldest son. Which is the correct answer? Till she gets remarried. It's not for a fixed term, it's not for 20 years or 10 years, something like that. It's not that till her children become adults, no. It's not that till the marriage of the eldest child, no. But till she gets remarried again, where she becomes again the responsibility of the second husband. So we will mark option C as the correct answer, till she gets remarried. Now coming to question number 4. Which offences, the offences for which a police officer can arrest a person without a warrant is non-bailable offence, non-cognizable offence, bailable offence, or cognizable offences. So the correct answer to this option number D, that is cognizable offence. I have given you one video where we have been discussing or differentiating between bailable and non-bailable offense and cognizable and non-cognizable offenses. So please do refer to them for detailed knowledge as to what I am talking about in this, or why I'm marking option number D, cognizable offense, as the correct answer. So I mark option D, cognizable offense. Moving to question number 5. In law of torts, always unliquidated damages are awarded. What does it mean by unliquidated? Option A, non-ascertainable. Option B, approximately arrived at. Option C, neither A nor B. Or option D, A and B both. It's definitely option A, which is non-ascertainable. So in the law of torts, always unliquidated damages are awarded. It means by unliquidated means it's non-ascertainable. Moving to question number 6. Which constitutional amendment act is termed as mini constitution? 41st Amendment Act, 42nd Amendment Act, 43rd Amendment Act, or 51st Amendment Act? So while discussing the amendment, I had been discussing this, which is 42nd Amendment Act, and it's a very, very important part. We usually tend to get questions from this part, 42nd Amendment Act. So this Constitutional Amendment Act is called almost a mini constitution because various articles had been amended. Moving to question number 7. Dash is an act which is perfectly legal but can be rescinded. Option A void, option B voidable, option C vis major, option D volenti non fit injure. So which is the correct option of question number 7? So I guess you all have identified by this time that is option number B, that is voidable. Voidable is an act which is perfectly legal but can be rescinded. Now we will move on to question number 8. The expression socialist was intentionally introduced in the preamble by the Constitution in the 42nd Amendment Act 1976. Its principal aim is to, option A, eliminate inequality in economic and political status. Option B, eliminate inequality in political and religious affairs. Option C, eliminate inequality in income and status and standards of life. Or option D, eliminate class-based society. So by the expression socialist, according to 42nd Amendment Act, its principal aim was to eliminate inequality in income and status and raise the standards of life. That is option number C. Moving to question number 9. 6 persons assembled on a platform of New Delhi railway station and started fighting with each other. The passengers present at the railway station got annoyed and felt disturbed. The public reported the matter to the police. These 6 persons are guilty of unlawful assembly, rioting, affray, or assault. Which will be the correct answer? So option 9 is definitely C, that is affray. They were reported to be affray. It was not unlawful assembly, not rioting, not assault, but affray. That is option number C. Moving to question number 10, Magna Carta, very important part of your syllabus. What is Magna Carta? Magna Carta, a milestone which preached about liberties of people of England, came into existence in 1200 AD, 1210 AD, 1215 AD, 1220 AD. So the correct answer is, when did Magna Carta come into existence? It was 1215 AD. Moving to question number 11. Confession of an accused is irrelevant and uh, inadmissible when made in the custody of a police officer, but in the immediate presence of a magistrate. Option B, before a magistrate who told that if he made a full confession, he would be released. Option C, at the time when he was drunk. Or option D, in police custody if it leads to the discovery of any fact. So according to this, option B will be the correct answer, where it says confession of an accused is irrelevant and admissible when made at the time when he was drunk. That will not be considered. That is option number C. Now we move on to question number 12. Uh, so question number 12 says, citizens have a fundamental right to approach a court of law through the option A, right against exploitation, right to constitutional remedies, right to freedom, or right to equality. So citizens have a fundamental right to approach the court of law through definitely option B, that is right to constitutional remedies. Moving to question number 13. We borrowed the idea of parliamentary system of democracy from Sweden, Canada, USA, or England. See, all these questions have already been discussed, so you can refer to those videos where I have discussed about democracy or a constitution, from where we have adopted it, what kind of constitution we have, and so various things have been discussed. You can refer to them. For this question, that is from where we have borrowed the idea of parliamentary system of democracy, it's option number D, that is England. Moving on to question number 14. The President of India is directly elected by the people. Option B, indirectly elected by the members of the parliament. Option C, indirectly elected by the members of the state legislature. Or option D, indirectly elected through an electoral college. It's definitely option D. You must have heard of what an electoral college is. So the President of India is indirectly elected through an electoral college. Now moving forward to question number 15. In what proportion the members of the Rajya Sabha retire? All the members retire at after 6 years. Half of the members retire every 3 years. 1/3 members retire every 2 years, or 1/6 members retire every year. So you might know this answer is because this was a question which we have studied in a school level also. That is, all the members do not retire after 6 years. Not half the members, they don't retire after 3 years. But 1/6 members also do not retire every year. It's 1/3 members retire every 2 years. So the members of the Rajya Sabha retire in the proportion of 1/3 members retiring every 2 years. Now moving to question number 16. Question number 16 says, who is authorized to decide over a dispute regarding disqualification of a member of parliament? Option A, the election commissioner. Option B, the speaker of the Lok Sabha. Option C, the president of India. Option D, a committee specially set up by the parliament for this purpose. So going by this question, question number 16, the correct answer is option number C. That is, who is authorized to decide over a dispute regarding disqualification of a member of parliament? It's not election commissioner, not speaker of Lok Sabha, not committee specially formed by parliament, but definitely it's option number C. That is the president of India. Next, moving on to question number 17. Which of the following persons can attend the session of the parliament but has no right to vote? Option A, the speaker. Option B, the comptroller and auditor general. Option C, the chief justice of India. Or option D, attorney general of India. So the person who can attend the session of the parliament but has no right to vote is option number D, that is attorney general of India. Moving to the next question, question number 18. Defamation by means of writing, print, etc. is legally called libel, libel, liber, lex scripta. So this, I think we all know defamation. If you're not aware of the term defamation or what does it talk about, do refer to the video that has been made and you will get to know the answer. It's libel. Option number B, that is libel. Moving to the next question, question number 19. The national song Vande Mataram was composed by option A, Rabindranath Tagore, option B, Bankim Chandra Chatterjee, option C, Mahatma Gandhi, or none of this. I guess this question will not require any explanation or will not require for me to give you the correct answer. The national song Vande Mataram was composed by Bankim Chandra Chatterjee. That's option number B. 19B is the correct answer. Moving to question number 20. The national anthem was adopted by Constituent Assembly on option A, 27th of December 1911, option B, 27th of December 1949, option C, 24th January 1950, or option D, 26th of January 1950. So here the correct answer that the national anthem was adopted by the Constituent Assembly on option C, 24th of January 1950. So we will mark this. Now coming to question number 21. The first law officer of the country is the Chief Justice of India, Attorney General of India, Chairman of Law Commission, or none of this. The first law officer of the country. If you have some knowledge about history or about constitution, you will definitely know this, that it is the Attorney General of India. Okay, he is the first Attorney General of India, is the first law officer of the country. It's not the Chief Justice, not the Chairman, not none of this. It's not Attorney General of India. Now moving to question number 22. Public holidays are declared under Negotiable Instruments Act 1881, Contract Act 1872, Public Employees Act 1967, or none of them. The public holidays are declared under, we all know that it's Negotiable Instruments Act of 1881. Which and when will be the public holidays? It's under the Negotiable Instruments Act of 1881. Now moving to question number 23. Who is responsible for introduction of public interest litigation in India? Option A, Justice P. Bhagwati. Option B, Justice N. Venkatachalia. Option C, Justice A.M. Amadi. Or option D, Justice B.R. Krishnan Iyer. The person who was responsible for introduction of PIL, that's public interest litigation in India, was Justice P.N. Bhagwati. Moving to the next question, question number 24. Who was the first Attorney General for India? C.K. Tapatri. Option B, M.C. Setalvad. Option C, Nani K. Pakhyawala. Option D, Niren Dev. So the first Attorney General for India was M.C. Setalvad. Moving to the next question, question number 25. Law and sense are not the same thing. This was said by Mr. First, number 1, N.K. Gandhi, Mohandas Karamchand Gandhi. Option B, Jawaharlal Nehru, J.L. Nehru. Option C, Jinnah, or option D, M.N. Venkatachalia. So this famous line was definitely none other than option B, that is J.L. Nehru or Jawaharlal Nehru. He correctly told that law and sense are not the same thing. You cannot confuse law with sense. So the correct answer to this is option number B, J.L. Nehru or Jawaharlal Nehru. Moving to question number 26. Law is an act was said by option A, Marx, option B, Charles Dickens, option C, Locke, option D, Abraham Lincoln. Law is an act was said by Charles Dickens. Moving to question number 27. The Universal Declaration of Human Rights was adopted by the UN in 1946, 1947, 1948, or 1949. So the Universal Adult Declaration, if you have got some idea about this, so this was adopted by UN in the year 1948. Just after our independence, we have been very much worried about Universal Declaration of Human Rights, and this was correctly adopted in the year 1948, and from then onwards, it has been playing a significant role in our part of Constitution. Coming to question number 28. Double jeopardy is a two-edged weapon. Option B, a dilemma. Option C, a confusing expression. Option D, a second prosecution after the first trial for the same offense. So if you have read about double jeopardy, or if you have heard me saying about double jeopardy in the previous videos, it's not a two-edged weapon, not a dilemma, not a confusing expression, but the second prosecution after the first trial of the same offense. Now we'll move on to question number 29. Question number 29 says, conspiracy is option A, absconding from the police, option B, secret plan to commit a crime, option C, disobeying the criminal process, or option D, willfully deceiving of the fact. And conspiracy is secret plan to commit a crime. We often use this word conspiracy in many of our day-to-day life. We do talk about it. So conspiracy is not absconding, not disobeying, or not even deceiving. It's secret plan to commit a crime. That's called conspiracy. Moving to question number 30. That's the last set of questions for this set. Incredible means option A, surprising, option B, interesting, option C, disgusting, or option D, unbelievable. So it is option D, which is unbelievable. Incredible means unbelievable. So for this, I guess you need not have some knowledge about law. Incredible. This was a very common English also that we have been knowing. Incredible means unbelievable. So this was practice set 2 that I have been discussing in this video. In the previous video, I have discussed the entire practice set paper 1. In the following videos also, we will be discussing practice set paper 3 and so onwards. Do refer to them. It's very important and very helpful also for solving these MCQs. Also do refer to the contents or the structures made where law and all of these concepts have been clearly discussed. So if you follow those and then you come to the practice set paper, I guess that will be quite helpful since you will be able to solve along with me in this video. So I will conclude my video here for today. Thank you for watching this video and all the best for your career ahead. Stay happy, stay safe. Thank you.